So with that in mind, let's talk about what's an enforcement action, okay? Enforcement action is basically a lawsuit where one party is suing to enforce the governing documents against the other party, okay? Now, the other party is going to either be the HOA and or another member, because nobody else is going to be governed by your governing documents,
That's
but
right.
those two parties. It can be both and or, but it's going to be against your neighbor. For example, if you're going to file a lawsuit against a neighbor for causing a nuisance, okay, you're going to sue for nuisance, and you're going to sue, which is there's a statute on that in California, not part of the Davis-Stirling Act, but you're also going to sue for enforcement of the governing documents precisely because you want to get your attorney's fees upon prevailing. If you just sue for nuisance, that statute does not have an attorney's fees clause.
Yeah.
And there would be no contract involved. So when you just sue for nuisance, you don't get your attorney's fees. But if you sue for nuisance and enforcement of governing documents, or just enforcement of the governing documents, then lo and behold, you prevail, you get your attorney's fees, because 99.9% of the CC&Rs out there have a provision saying you can't cause a nuisance. You can't interfere with the quiet enjoyment of somebody else's property.